Hello, everyone. Thank you so much for your patience. We are ready now to get started. We'll be going live on Facebook as well. So for the people who will be speaking, please feel free to have your video on. To start on the session, I'll have the speakers introduce themselves. David, you can go first to introduce yourself.
Hi, everyone. I hope you can all hear me. So my name's David Kagino, investment manager at Fine Consult LLP. In Fine Consult, we're a transaction advisory firm, whereby we assist our clients in raising either debt or equity funding, as well as their strategies. So whether that's going into a new market or expanding in the existing markets they're in, we assist them in that. We're based in Kenya, but we also have an office in Rwanda, and we've been in operation for the last 7 years. Thanks.
Thank you so much, David. Hi, Ivan. Please introduce yourself. You're on mute. Please unmute yourself.
Sorry about that. For some reason, my laptop just froze. I hope you can all hear me. I don't know if the background is making there's too much light in the background that I'm already dark skinned. I don't know if it looks darker, but nonetheless, let me introduce myself. My name is Ivan Ojakol. I'm a lawyer practicing in Uganda. I'm also a lecturer of law at a university called the International University of East Africa. I'm a partner at a law firm called Matrix Advocates, based in Uganda. International trade, intellectual property are some of my specialist areas. And I'm really, really happy today to make my contribution on this protocol, which is still in draft, but hopefully can have a final one before the end of this year. So thank you, everyone, and I'm happy to hear from you. And I'm also happy I hope we shall have a very lively discussion about the AfCFTA Intellectual Property Protocol. Thank you very much.
Thank you very much, Ivan, for that. We look forward to a great discussion. So I'll just talk a little bit about the AfCFTA protocol. Within the session, for the attendees, kindly do remember that this is an interactive session, so feel free to have any questions. Also, if you have any questions, put them down in the chat box as well. So the AfCFTA, the African Continental Free Trade Area, that is bringing together 54 African countries just to create a single continent market. And then the agreement itself was entered into force on 30th of May 2019, when 24 countries had ratified the agreement. So the operation phase of the FTA was launched by the African Union on the 7th of July 2019, and then entered force in the 30th of May in 2019. So for this particular, in numbers, we have statistics that we are looking to preferably achieve 1.3 billion people across 55 African countries. The GDP is valued at $3.4 trillion US. 30 million people are to be lifted out of extreme poverty. The raise in income is 68 million others who live less than $5 per day. And then we are also looking to boost wages for both skilled and unskilled workers. So the negotiations under the AfCFTA were categorized into 3 phases. Phase 1 was covered in the protocol on trade in goods, trade in services, and dispute settlement. So phase 2 covered protocol on intellectual property rights, investment, and competition policies. And then the phase 3 will cover protocols on digital trade and women and youth in trade. So the phase 3 negotiations are expected to commence anytime following the completion of phase 2. The phase 2 negotiations on the agreement were recently concluded, and they included the development of an intellectual property right protocol, which is what we are here to discuss today. The protocol aims to support the realization of the objectives as set in the Article 3 of the agreement by seeking to establish harmonized rules and principles for the promotion, protection, cooperation, and enforcement of intellectual property rights. The protocol was recently released to the general public, and we are looking to have more insights on the same today. So I think we'll go straight into the questions that we have for our particular speakers today. The first one being, maybe David will take this one. Tell us the importance of the IPR policy in international trade.
Thanks for that. I'll use my own understanding of intellectual property rights and what they help to spur. So I believe we all understand intellectual property rights are basically the rights given to creatives to protect their creation. So if I am a singer and I produce a song, my interests are supposed to be taken care of, but at the same time, my song should be circulated that the public will benefit from it. But any financial gain that I'm to get from my creation, I'm supposed to benefit fully from it. So I believe IPR is very, very important for international trade, especially in the context for the AfCFTA, because part of the fundamental principles that AfCFTA promotes is the transfer of technology and transfer of, ideally the transfer of technology. And if we are not able to protect IP, the creations of people who develop new software, develop new code, or develop new ways of doing things, if those creations of their mind are not able to be protected, then ideally we don't promote technology. We're not promoting the development of new technology, because those who are coming up with those new ideas, they're not being protected, they're being exploited. So I think intellectual property rights are crucial for international trade, especially international trade that's trying to promote technology development in new sectors of the economy. So I think it's crucial. Yeah, I think there is about 2 or 3 other protocols that touch on the importance of a technology transfer, aside from the IPR protocol, of course. So that's why I believe it's very important. Yeah.
Thank you so much, David, for those particular insights. Again, to our audience, if you have any questions, feel free to put it in the comment section. So the next one goes to Ivan. What is the status of IPRs, policies, and regulations in Africa? Ivan, you're on mute.
Hi, I just beg your pardon. For some reason, I don't know if it's from your side. I sort of froze a bit. I just beg your pardon on the question.
Okay, that's fine. The question is, what is the status of IPR's policies and regulations in Africa?
You're breaking up again. I can't quite hear you. I don't know.
Okay, let me switch off my video. That might help with the network. The question is, what is the status of IPR's policies and regulations in Africa? David, might you have had the question? I think Ivan might have dropped off.
Oh,
okay.
You're breaking up, but nonetheless, if I got your question, you're saying what's the state? Yeah, your network has issues. What's the status of IPR policies and regulators in Africa? Is that what you're trying to say? Well, I cannot speak for every country, but I know that, for example, right now in Africa, there are perhaps 2 main bodies. Of course, in line with something called the principle of territoriality, every country has a right to regulate their intellectual property policy and laws, or to govern their intellectual property regime. And you find that countries have individual laws, say, governing copyright, trademarks, industrial property, That's usually patents, utility models, industrial designs, etc., and other emerging areas like geographical indications, traditional cultural expressions, traditional knowledge, etc. So countries, yes, do have their own internal mechanisms, laws, policies, etc., of governing this. But largely, there are two sort of Pan-African or continental bodies that have helped with ensuring that beyond the country's territory, the country can also, rights holders can also be able to protect their intellectual property elsewhere. That is the African Regional Intellectual Property Organization and the Organization on African Intellectual Property, or OAPI, or OAPI. But largely, OAPI is West African countries that are signatories to it, and it has helped in protecting their rights that side. And for it, as opposed to ARIPO, it is sort of a one-stop shop mechanism for protecting your IP. If you register with the OAPI, you can protect your IP across all the member states, as opposed to ARIPO, where you that has sort of a dual mechanism of you can protect your IP, for example, in Uganda, but also when you register with ARIPO, you can then protect it in the other 20 or so member states. So for OAPI, it is a one registration that protects you across the board in all the countries that are member states. While for ARIPO, it is protecting you in Uganda, for example, and also in all the other member states. So you sort of have a dual mechanism. So centralized, it helps. ARIPO just helps you with protecting your IP or, for example, your trademarks elsewhere, where it's not registered other than in your territory or in your country. Well, for OAPI, you can, with one registration, you can protect your trademark, for example, across the board. So that is a major divergence, which I hope and hoped that this AfCFTA IP protocol would help in addressing. I don't know if it has addressed that, perhaps shall discuss that later. But again, beyond that, there are many other countries in Africa that are not members of any of those bodies. And that creates one of the greatest problems as far as implementation and protection of intellectual property across the board is concerned. And of course, with that, again, is there's a lot of appropriation of African intellectual property, what you'd call African intellectual property, traditional knowledge, geographical indications, EDC, traditional culture expressions, genetic resources, etc. Because many countries have not looked at the value of protecting that IP. There are very few that there are. What should I call it? It is just a few countries that have perhaps recognized that and tried to protect their those other what you call the more African intellectual property beyond trademarks and others, and also beyond that, there's a lot of emerging intellectual property issues which perhaps you'd think through a regional mechanism would have been protected. So would have been countries that have come up with very coherent and organized ways or organized policies for protecting. For example, when it comes to emerging technologies that are cross borders, there seems to be divergences, for example, on things like intermediary liability and copyrightability of that, EDC and other things as far as that is concerned. So Africa, yes, is alive to intellectual property and what it is, but perhaps has not protected its IP coherently enough. And perhaps AfCFTA would have been that opportunity. But for my looking at the protocol, perhaps has not really addressed that comprehensively, and maybe we shall discuss that at a later stage. So the state of protection of IP in Africa is really at a nascent stage. And especially because of the discrepancies in internal policies, internal laws, and just also these other things of Francophone and Anglophone also come in, and perhaps that's why we have that distinction between OAPI and ARIPO. So we are still at an nascent stage that perhaps we have hoped that the AfCFTA, maybe when it's done, the protocol, you can have a more coherent mechanism for. But from looking at it, perhaps there's still a lot to be desired. I don't know if I've answered that question.
Yes, thank you very much. Can you hear me clearly now?
Oh, yes, I can.
Awesome. So for the next question, preferably David could take this. What are some of the common IPRs limitation in Africa? And do you think that the AfCFTA has a potential to exacerbate these particular limitations?
Yeah, some of those, I think Ivan has touched on a few of those limitations that we have. So as he mentioned, there are two major systems that guide IP in Africa. But even how they are being applied is different, right? Even between those two systems. If you go at the national level, you'll find there's still differences within how IP is being applied. I think in the EAC, if you look like between Kenya and Rwanda, I don't know what doctrine it is. I think national recognition or something like that. The Kenya and Rwanda subscribe to two different doctrines, despite the fact that they are both within EAC. So at the regional, at the Pan-African level, we have two systems. Application is different. You get to the national level, you might have the same system, but again, even at that level, the application is different. So one of the challenges is that from how it looks, everybody is following their own different system of how they recognize those IPs and how they enforce them and how they register them. It's all different. So AfCFTA is coming up, and I think part of the institutional arrangements under it is to have, and I believe this is also the objective of the protocol, is to have one system that we can all follow that is harmonized. So if you're registering IP in West Africa, you're registering IP in East Africa, you should ideally be having the same mode of systems. So that's one of the biggest challenges that this IP registration and the whole IPR issue in Africa is facing. And I believe AfCFTA, by trying to harmonize all these processes, we'll be able to achieve it. And number two, I think also there is, from the businesses that we've interacted with at our firm, there's a significant lack of awareness regarding IPR. You will find majority of entrepreneurs and majority of businesses don't know, even at the national level, what are they supposed to do to get their IPs registered. How do they even go about through that process? Now, yeah, I believe it would be even more difficult for them to know how to do that if we went on a continental level. So to solve that problem, I like the fact that not only in the IPR protocol, but also other AfCFTA protocols, the national bodies responsible for those matters are being involved in the formulation of these laws. So I think that way, information will trickle down to the businesses existing within those national levels. So for me, I am identifying two major problems. The systems of IP are different at the Pan-African level, also at the national level. And number two, there's a significant lack of awareness. If you talk to most entrepreneurs on IP, and I'd even throw this to those who are listening here on the protocol, how many of you would know what to do if you needed to register your IP in whichever country you're in? Would you know the exact processes you're supposed to take? Or will you need to go and find out that and then come back and be able to answer that? So I think for me, those two challenges are the issue. AfCFTA seems to be adopting a structure that will seem to address it. They're harmonizing these systems. And at the same time, they're working with national bodies that are responsible for monitoring IP to get them involved in the process of forming this one continental plan that we have. So I think that way now, awareness gets down to the business level. Yeah.
Thank you so much for that. Having spoken about the limitations, what do you think is the scope of application for this particular protocol, and how will it relate to national investment laws and policies in AfCFTA member states? Ivan could take that particular question.
Thank you. I think the discussion of the investment protocol was yesterday. But nonetheless, of course, intellectual property is very vital for investment in Africa. And in the discussions I can see some of Africa's leading intellectual property minds are on this call. The discussion leading up to to the negotiations and drafting. This draft, by the way, it's just a draft. We haven't seen the final version of this protocol, and perhaps we may be prematurely discussing it. There were discussions among many leading IP minds of what approach we take. Should we take the OAPI approach, or should we take the ARIPO approach? And if we were to take, for example, the ARIPO approach, how will that help as far as a coherent investment policy mechanism regime is concerned in Africa? Because it is, like I mentioned, when it comes to OAPI, it's more or less a single registration that more or less protects you across all the member states. And in line with the AfCFTA, which you would think would help in creating a certain level of coherence in line with the concept of intra-African trade, increasing intra-African trade. But it is still, again, let's go back to the wording, for example, of Article 4 of the Mother Agreement that says that state parties shall only cooperate when it comes to intellectual property and investment policy and the other things. So the use of the word cooperate is very, very interesting. It is a loose language in international trade that means that perhaps it's not binding. And maybe the drafters and the people who are negotiating these things on our behalf are alive to the fact that perhaps regulating intellectual property in a uniform way may be very complicated, or even the fact that there are all these divergences and contradictions as far as intellectual property is concerned on the continent. Maybe that's why they come up with the language. So, and indeed, true to that, if you look at across the board as far as the protocol is concerned, this draft protocol, you will see a deferment or a sort of a certain level of respect towards state parties as far as their right to regulate and govern intellectual property is concerned. And also, I think it's an Article 24, so sort of a cooperation mechanism that countries must cooperate. It's not entirely saying that this is binding or this will be uniform across. It's saying, I mean, even when it comes to copyright, countries shall ensure or shall come up with their own mechanism, etc. Things like those. Of course, there are some aspects throughout the protocol where it more or less asks them to work together and come up with coherent mechanisms of governing certain areas. But for me, that is a problem, because an investor going to Benin may have a different way, may face or encounter a different mechanism or regime for, say, registration of their trademark or registration of an industrial design, and also come to East Africa or Uganda and find that, guess what, this is a bit different. So an investor that is trying to trade across the board or across the continent may face those problems, like also David had mentioned. So the lack of coherence, again, from the reading of the protocol, that seems not to really have adopted any of the mechanisms or any of the models, be it ARIPO or API, is a bit of a problem. But again, maybe nonetheless, it's a practical or a pragmatic approach, because the guys negotiating these things are aware that, guess what, we may shoot ourselves in the foot, or we may come unstuck when we attempt to legislate and say, no, this should be everything that we register under one body and it is binding across the board. So maybe that is not that in consideration. But also, as far as investment is concerned, maybe but one thing I could pick out perhaps is the exhaustion of intellectual property rights is catered for, and maybe that could come in handy as far as investment is concerned, because the moment someone sells their IP or consents to the use of their IP, then and you find your product being used in another country where perhaps you think you did consent, but again, it is through, maybe it arrived in that country through a person that you sold to, or you consented for the use of your IP. Maybe you have no right to come and claim that there's an infringement of my patent, or there's an infringement of whatever you be claiming. Maybe that could help, because I mean, exhaustion of IP, the moment you sell it, you sell your IP, and the moment you consent to the use of your IP, you may not claim certain things as far as infringement is concerned. Maybe that exhaustion. But again, the protocol is not complete, because it keeps on telling us there will be annexes to provide for these things, to provide for conditions, how this exhaustion of rights will proceed. So maybe until we see the final protocol is when to be able to properly determine. But for my reading at this stage, it seems we may not have resolved the aspect of uniform investment and us moving and an investor who's coming to the region uniformly being sure that this is the intellectual property regime in Africa. They are still going to encounter all different aspects and all kinds of contradictions across the board. So I don't know if I've answered the question, but that is what I would say.
Yes, thank you very much. That was a lot of insight. I just wanted to ask a follow-up question, preferably to David. What do you believe to be the relationship between this particular protocol in IP and other protocols of the AfCFTA? And what are the institutional agreements under the protocol?
So the first part, what's the relation?
Yeah.
So remember, having good IP laws allows the movement of goods and services. As Ivan has mentioned, I might go to another country and allow my IP to be used commercially by other people. So that would ideally be allowing me to take my creation and maybe somebody develops an industry that does a goods or service out of it. So IP is related to, when I pick out the protocol on trade, the protocol on, goods and service, goods and the protocol on services, as well as the protocol on investments. If we have good IP laws, once we figured out the regulations, because as of now, what we have in the protocol is it just stipulates how we're supposed to operate, but I don't think anything has been cast in law yet. Once you have the laws that guide how IP moves around, if I'm trying to make a decision of whether to take my investments to another country, and I'm well aware of all the IP regulations and how to protect my IP in that country, then it promotes investment. If I know that my creations will not be exploited, and by the exploitation means someone else uses them, gets the financial benefit out of it without me getting a piece of the cake, then I'll definitely be motivated to take an investment there. So I think that's how this particular protocol relates to the protocol on investments. And ideally, if you're relating to the protocol on investments, you're relating to the protocol on trading goods and services. Borders open up when regulations are understandable and they are fair across the board. So it opens up. Very good example. If I take my products and without mentioning the countries, I'm sure you'll know, within the Western nations, countries where IP is heavily protected, and there are countries where you go, your IP is thrown out of the window. If you are a person who wants to put in money in the country where the IP is thrown out of the window, I think knowing that, you might decide not to invest there. So that's how it relates to the other protocols. Second question, what are the institutional arrangements? Like I mentioned, there is to be an agency, or should I call it the office? I think that we're calling it the office. Ideally, this is one central body that will be in charge of, or would be enforcing and monitoring IP across the entire continent. And as Ivan said, this institution, the conversations being had now that would guide this institution is, do we adopt the OAPI protocol or the OAPI method of recognizing IP, or do we go the report route? So there's an institutional arrangement under it, and that will be the organization that will be keeping an eye on IP across the continent. And I believe now, if we have one system that we're all following up, it doesn't matter what country you're coming from. It doesn't matter what IP you're registering. You're well aware that, number one, it's easy to get it registered. If you go to the other country, your IP will be respected, and if it's to be used, you'll gain financially. Yeah, so your creations of your mind will be protected, whatever part of the continent you're in. Yeah.
Awesome. Thank you very much. To Ivan, in your opinion, what is the implication of the protocol to AfCFTA member states and businesses in Africa?
Well, that's an interesting question. Well, it basically means that intellectual property is a serious issue, and it is very important for the fulfillment of the objectives of the AfCFTA. And but importantly, it's quite ambitious because it introduces some not necessarily new, but it shows us that perhaps there are certain African-centric IP areas that we need to think about, and areas like traditional knowledge and traditional cultural expressions, genetic resources, folklore, etc. I think I've always had those debates about the appropriation of things like the Masai clothes and culture and everything else by the Western world and Hollywood and etc. without a proper trickle-down effect. So it's basically telling member states or state parties that, guess what, this is serious, and please come up with the legislation internally, or at least through a regional perspective, or from a continental level, we should aspire towards ensuring that we have a proper trickle-down effect and a proper share. I think it's called a sharing and benefit mechanism under this protocol, as far as these are concerned. It is, in light of COVID-19, it has become alive to that, and it's telling us that public health and promotion of local production of drugs is also very, very important. And please ensure that you, as much as possible, implement the TRIPS Plus flexibilities. I think the amendment 2005, as far as allowing poor countries like in Africa through compulsory licensing and through other mechanisms for us to be able to access these drugs. And also technology transfer as far as empowering our local industries. Ensure that they can, in the long run, be able to come up with these drugs, as we saw with the debacle that was COVID-19. Emerging technologies is also telling us that, guess what? There are things like artificial intelligence that are coming around. How are you going to deal with this as far as intellectual property is concerned? Please find a way of cooperating and coming up with mechanisms so as to address some of these emerging technologies. I'll be interested in seeing how that is addressed, especially in light of some of the jurisprudence that comes out of the Western world, especially the USA, when it comes to this technology. I think IP lawyers and practitioners on the call, some of them were amazed by the decision in Google versus Oracle, where very interesting way of applying the exception of what's the exception called? Can you imagine? I forget the exception. The exception under the regular section 15 as far as our copyright acts are concerned. The fair use exception, very interesting and innovative application of the exception by the US Supreme Court in order to protect their technology industries was applied. And things like those are things we should be alive to. When it comes to technology, are you going to outrightly, strictly enforce IP rules? Those are things that we should be thinking about. It keeps on talking about annexes that will be developed, the whole protocol. I want to have a look at those annexes and see how these things are properly going to be developed. But by and large, the protocol is telling us that IP is a serious thing. But importantly, let us think about some of these emerging areas in IP, or some of these Africa-centric, or some of these areas that are going to develop Africa, take us out of poverty as far as intellectual property is concerned. But also, it's also telling us that, guess what? It is a bit complicated for us to regulate IP like this. So more or less the ball, this is the AfCFTA telling us to regulate intellectual property from a centralized perspective. So the ball is in your court as individual countries or as regional economic communities to ensure that you properly come up with coherent mechanisms of ensuring that there's uniformity and there's cooperation, as it keeps on saying, cooperation in the application of intellectual property, so that you can be able to develop as Africa. So I don't know if I've answered your question. That would be my answer.
Yes, and we have a question in the chat. In line with the lack of law enforcement, issue of counterfeit of goods and online piracy, etc., our continent is not a favorable market for innovators, in my view. A case in point, COVID-19 booster and vaccine. Hence, considering this matter in line with TRIPS and Article 31 of GATT, what do you think AfCFTA helps African countries a way forward? David, would you like to take that?
Okay, I'm trying to also read the question so that I understand what the issue is. I think this person is pointing out that African countries do lack law enforcement, some of them. There's issues of counterfeit goods, and there's online piracy. Continent is not a favorite market for innovation. So I think, okay, so if I'm understanding this question correctly, the first part, they're ideally pointing out the challenges that African nations are facing and trying to ask, with relevant to TRIPS and Article 31 of GATT, what do you think AfCFTA helps African countries as a way forward? Okay, I'll try and answer this question how I'm understanding. So I think in all the sessions we've had for these three principles, what we've always mentioned is one key thing. So AfCFTA is not, let's take, for example, the issue of lack of law enforcement. I don't think if it's at the national level, I don't think AfCFTA can do anything to sort you out on a lack of law enforcement. AfCFTA is not going to provide you funding to set up a police force, for example. If you're having online piracy issues, and that could be, of course, again, there's no enforcement to ensure that doesn't happen at the national level. There's really nothing that the AfCFTA can do that is revolutionary. What the AfCFTA tries to do is build capacity of institutions that would be in charge of monitoring that at the national level. And I think this also came out during yesterday's session. I think sometimes we think AfCFTA is going to come in a country and sort out your own internal issues. I don't think it is. I think what the AfCFTA is trying to do is say, this is the direction we're supposed to move to monitor IP at a continental level. However, at the national level, there's a job that each country has to take. I think Kenya, we have a national AfCFTA implementation strategy, and I think it ends in 2027. I'll just check that. So you see that's an example of a country saying, there's this big plan that we're trying to get to, but there's things internally I need to sort out before I start going there. So again, AfCFTA is not going to sort out national stuff. If you look at certain protocols within AfCFTA, when it gets to the national level, they don't have jurisdiction on that. Like, for example, the competition protocol. If there's something within if the matter that is being addressed is within the jurisdiction of a national competition regulation agency, the AfCFTA has no say on that. They will say, well, the national guys are the ones to deal with that. So to answer this person's question, if the challenge you're identifying, like, lack of law enforcement, that is a national challenge, I believe. If a country is not proactive in trying to sort that out, I don't think they can reap the maximum benefits from having AfCFTA, because now, if within your own country you don't have an enforcement body, how are you going to be able to ensure that IP regulations set at the continental level are followed within your country? You're simply not going to be able to do that. So national issues, AfCFTA doesn't solve. It helps in capacity building, yes, and they would provide resources for that. But if that incentive is not there at the national level, there's really nothing they can do, right? I think even Ivan has mentioned, every country has a right to regulate themselves the way they want to. So if that's not a priority, but what's the Secretariat going to be able to do about that? Yeah.
David, if I may add on, just maybe perhaps from the letter of the law, I can see here the Article 12. For example, as far as medicines is concerned, I don't know if this question was on it, because I can see it picks up innovators and medicines and agency. The protocol seems to mandate, I think again, after the legacy of COVID-19, that state parties shall not hinder access to medicines. Then those that have not ratified the 2005 amendment to the TRIPS agreement, ratify it and ensure that such can enable export of pharmaceutical products produced under compulsory licensing. And then those that are not members of the World Trade Organization, again, within 3 years, provide for procedures that enable the export of pharmaceutical products. So it attempts to create that sort of obligation of each member state, so state party, and even those that are not parties to the World Trade Organization, to ensure that, at least as far as access to medicines is concerned, especially after COVID-19, that we do not ever go back to that. So I don't know if that partly answers this question.
Yes, it does. And I have a question. The next question goes to the both of you. How do you think that this protocol can best be implemented and domesticated within the member states?
Just repeat the question again. I lost the network.
Sorry. How do you best believe this particular protocol can be implemented and domesticated within the member states?
How best do I think it can be implemented and at the domestic state, yeah?
And domesticated within the member states.
I think this question has been repeated in another protocol that we discussed. I like the AfCFTA's approach of building capacity at the national level first before trying to build out this whole huge plan that we have. So I think that helps in bringing first an understanding, and number two, the know-how of how to implement some of these protocols at the national level first. So take, for example, this particular protocol. If we go to a country and we find, I think Kenya, we have KIPI. So if you go to another country and you find IP registration or regulations around IP don't actually exist, there's nothing that we're doing by saying we're putting up a plan at the continental level, but then when you go to each of the individual countries, the regulations that would support the implementation of our plan don't actually exist. So I think that is one good approach that helps it be implemented and domesticated at the national level, to come in at the national level within the specific member states. I think that whole hand-holding process is very critical. There's the big question of where do we mobilize the resources to do that, and who bears that cost and all of that. But I think the goodwill in saying we're not just gonna sit at the top of AU and form all these plans without involving the guys at the bottom, bringing in those guys at the bottom of the who would ideally actually work to enforce these regulations, first training them and getting them to one equal level. It does help. I think it provides a lot of benefits, and we've been from our experience working across Africa, we've seen cases where you go to certain countries, some of these regulations that would guide efficient movement of goods and services don't even exist, or they do exist, there's just no enforcement body, or they do exist, there's an enforcement body, but it's a dog, it's all bark and no teeth. Yeah, so I think getting national level stakeholders that helps a lot. Yeah, that's just my view.
My just to add voice what David said. One, political will. Political will is perhaps first and foremost almost everything. Because one, if there is political will, you have proper IP laws. You don't have an IP law drafted by someone gray-haired and light white-skinned from somewhere, from somebody, I don't know, UNCTAD or wherever. You have African intellectual property experts who have developed expertise. Some of them are on the call, interestingly. So you will have African-centric laws. When it comes to things like plant varieties, you ensure that the African farmer is protected, or the local farmer is protected. You ensure that African genetic resources are protected. Geographic indications are protected, traditional knowledge is protected, traditional culture expressions are protected, folklore is protected, etc. So one, political will. Political will also means the politicians appoint the right people to come up with the laws. You will not have laws that have things about semiconductors, clearly a copy and paste from some European law, like many of our industrial property acts have in Africa. It's meaning some white man put it there in order to protect the industries. As you know, the chip industry is a very important industry in the USA, and that's why it's been a fight. I think there's a matter that's filed with the World Trade Organization either last year or early this year, I think last year, between China and the USA. So that is number one. But importantly, again, to add voice what David said, there's an Article 24 here that talks about some of the things that should be done. Building capacity is very important, of course. Exchange of experience on examination of registrable intellectual property rights, automation and streamlining of intra-agency communications is another important one, through the use of information and communication technologies for efficient IP rights. So Article 24 also guides that. But importantly for me, everything, political will, and it's political will that will determine everything. So with that, that's my answer as far as that is concerned.
Just to follow up on the same, do you believe that maybe there are some of the challenges that will be foreseen while trying to implement these particular challenges? and maybe any suggestions in terms of solutions that you could propose to mitigate against those challenges.
Is that mine?
Both of you.
Well, for me, again, it's more or less the same as political will, number one. Yes, the politicians know what intellectual property is and its value. To know that there is more intellectual property or there is more value in an intangible asset that can lead and get a country out of poverty, as opposed to, say, a physical asset like land. And this is why, for example, the pharmaceutical world does some of the things it does to the rest of us, because they know the value of intellectual property. And this is why the technology world, the Western world, is that advanced, because of intellectual property. So things like those, and through intellectual property that shall properly get out of poverty, as opposed to these other things. So, but importantly, again, it's a bit of a problem in the wording of, and like I mentioned earlier, perhaps a pragmatic approach, knowing intellectual property perhaps is complicated, and countries and nations' rights to regulate internally, and also some of these embedded principles as far as IP is concerned, like principle of territoriality, etc. This is why the use of words like corporate and sort of this deferment to nation states to be able to sort of chart their path as far as IP is concerned creates a serious problem. And as a result of that, there's a bit of laxity or even laziness, if I may use that word, or just deliberate ignoring or deliberate refusal to follow through proper intellectual property laws. So that is a serious challenge, and perhaps it is the biggest problem. But again, all of this can be mitigated and resolved through the recommendations under Article 25, what I've said earlier. Build capacity, train intellectual property lawyers, who I think are now plenty in Africa, intellectual property experts, to properly develop these laws and get the politicians on board, especially the topmost politicians in countries, so that we can come up with proper laws that are Afrocentric and will properly represent our interests and interests of creators, interests of innovators, interests of the local African farmer or the local villager in some village in Niger or Cote d'Ivoire, so they can also be able to tap into the benefits of intellectual property. But also importantly, there are all these other intellectual property obligations that have been created by treaties, bilateral trade agreements that are just never followed. As far as IP is concerned. So they are just, again, political will and just ensuring and bringing these things to the attention of powers that be that, guess what, there is this and this. Let us put our house in order, and that is the only way we shall be able to mitigate some of these challenges.
Let me just add on to what Ivan has mentioned. To also agree with him on the political will. We need to have a lot of that. I think historically we've seen agreements even at the GATT and WTO level, especially ones I think that were touching on agricultural products. We've seen how when there's no political will, those agreements pretty much stop there, right? It gets to the national level where people need to debate it, and guys just say, we're not going to get involved in this, we're out. So political will is very key. Another challenge that I foresee, and I'm interested in seeing how this information will be disseminated. From past experience with clients we've had, there's a huge number of businesses that either have no idea that they need to get their IP, or when they realize that they need to get their IP is when they're selling their business. So they're getting an equity investor coming in, and then they realize, oh, if I had IP, my valuation could probably go up, or maybe I could argue a better case for the valuation that I have. So by the time they're realizing that they need to get it, it's usually at the level where an investor is already on the table. And it's either due to a lack of awareness, or they know about it, but they're just not motivated enough to go for it. Number three, we've had numerous businesses, for those who've been operating in EAC, who complain that some telcos have taken their ideas, or someone else saw the idea and went and implemented it. Again, they didn't have IP on it. And I'm seeing there's a question of someone who's asking along those lines of the cost for IPs on MSMEs. The challenge that I see and I foresee this protocol having, and what I wish they would do to sort it out, is I think this whole protocol, once we've agreed on all the legislation and if all the I's are dotted and the T's are crossed, we need to find a way of how to disseminate this information to MSMEs. And not just give them the information and go, but give them the information and give them a reason to act on it. Incentivizing them one way or another to get this done. It could be showing them the examples of getting an IP recognized and how that pretty much protects your business if you're able to expand, or helps your valuation go up. You know, if I have an IP registered and I'm the only one who's allowed to use it, and you want to come in and buy off my business, then you have to pay for that privilege that I've already given you. So I think AfCFTA needs to find a way, and it's not just the AfCFTA's role, it's us in the ecosystem. Evan has mentioned there's many lawyers on IP here. How do we find a way of how to move from our desks of professionalism and take this information that you have and put it in a very practical way that businesses can fully implement it? One of the things that I'll give an example that we do for especially tech-based businesses that we advise when they're trying to expand, we always ask them, how big is IP risk to you, or the lack of registration of IP? How significant of a risk is it to your business model? Does someone else have the capabilities, and this someone else could have more financial resources than you do, of taking whatever creations of mind you've created and fully implementing it and moving without you, right? So we always ask tech-based businesses, have an assessment internally and find out, if I pay X amount for this IP, what risks am I avoiding? And those risks, what's the cost of those risks to my business? Can I avoid it, or can I transfer that risk? So see, I like the question that Joy, I think, asked. To assess your cost for putting up IP, what are the considerations you're supposed to make? That's internal, right? Find out. This creation of the mind that I have, how crucial is it to the success of my business? The market that I'm going into, are there other bigger players who have more financial resources or more reach, who could simply take my creation, move away with it, and I'm left pants down? I have no business model. So it's up to you to decide, right? Of course, there's a cost implication to it, but what's that cost? What's the return on investment, or what's the security that it gives your business model moving forward? So those are considerations that you need to make internally when you're coming up with your strategy plans and all of that. So yeah, that's just part of the challenges that I've seen, more so touching on the on the small businesses, and it's a call to action to people who are IP experts. You know, how do we find a way of how to disseminate this information to the businesses at the lower level, but get them to actually act on knowing that information. Get those guys to register those IPs, especially businesses that IP is so crucial to either their valuation or the success of their business model. Yeah.
Thank you. And now that you've mentioned about consideration in terms of finances, where somebody, especially MSMEs, are looking to register the IPs, is it possible, maybe you can shed light, is it possible for somebody to, if I'm from Kenya or from a different country, is it possible for me to register my IP in Uganda if I find it more affordable and just ignore the bit of Kenya, or how is that going to work?
I'm avoiding giving a one-size-fits-all answer to this. I'll give in principle the approach that we recommend to businesses. Let me just try use a different example. What we tell our clients all the time is, and there's a tool we have internally that's called a risk assessment matrix that we usually structure. So what this shows you is, so let me use your example where you're a Kenyan business, maybe you're trying to enter into Uganda, or you're trying to operate in Uganda. And IP is critical for your business model. So in your risk assessment, what we'll analyze is the market that you're going into. Who are the guys who already exist there? Who are in the same industry or provide a sort of similar service to what you provide? Now, how using what we call points of parity and points of differentiation, we'll understand your IP based on the service that you're providing or the product that you're providing. How critical is your IP to your success compared to those other competitors? Is it an advantage that you have over them that keeps you ahead of the game as compared to them? If that answer is yes, then you definitely see why getting your IP is critical. Because if you go to that market and you show people a successful business model that is relying on your IP and your IP is not registered, what's stopping me, who's your competitor, from simply taking your idea and moving with it? Especially if I am a bigger boy and I have more reach than you do. It's very simple for me to just take it and move across with it. Number two, when you're looking of where to register, like Ivan mentioned, so there's some places you'll go and it'll cover you even outside that jurisdiction, or it'll just cover in that jurisdiction. It's up to you to understand the system that you're going for. If it's going to protect you nationally alone, then it's up to you to figure out. If you're ever going to go beyond the boundaries of that nation, you need to get another IP system. Now, if it gives you outside reach as well, then go for it. If at the end of the day, what you want to get is your IP protected. But the decision on the cost and whether you should get it or not, that boils down to internally as a company. Is your IP so critical? Is it something that you can put up in your SWOT analysis and put that under your strength? If it's under your strength section, then I would 100% vouch for you to get that IP registered, even if it means mentioning it when you're raising funding from investors and saying, hey, part of my funding is to actually get this IP registered. Then put it out there and say, by then I'm raising funding to register my IP because it's such a strong component of my business model. And if I don't have it registered and go somewhere else and somebody sees it and sees my success, I'm out of the game. Yeah.
Thank you. That was actually very good insight. We have another question in the comment section. Ivan, you could take this. During COVID-19 period, we saw how the effects of IPs led to protectionism and monopolism in human essential drugs, which affected Africa greatly. How does the AfCFTA plan to avoid such negativity around IPs within Africa innovation?
Well, I mentioned it earlier. I think it's an article. You can look at the Article 12 draft protocol. Article 12, it's Article 12.3. Article 12, sub-article 3 from A to C. So it's basically mandating that state parties must not hinder access to medicines and other things, especially as far as sharing them with the poorer countries is concerned. Then also those that have not ratified the amendment to the TRIPS agreement that allowed for exporting of pharmaceutical products under compulsory licensing must ratify that within 3 years, so they can be able to export those under the compulsory licensing arrangement to poorer countries that cannot afford those pharmaceuticals or drugs or medicines. Then even those that are not members of the World Trade Organization are also mandated to ensure that they come up with mechanisms or procedures that enable them to export those medicines under compulsory licensing for the benefit of those who do not have access to such. So it attempts to do that to rectify that problem. And hopefully it can be rectified eventually in case we ever have another pandemic.
Thank you. One question from the chat section also asks, could you tell us where is the starting point to start the IP protection for an MSME?
I don't know if David. For me, I would say look for an IP expert to advise you. As simple as that. IP expert. Selfishly, as a lawyer, I would say look for a lawyer, an IP lawyer to advise you. As simple as that. That's the starting point.
I like the honesty of Ivan. Yeah. Going to the experts is one thing. But I think from past experience, you need to define what your IP is. So for tech-based businesses, I don't know whether it's because most tech companies, they're pretty much tech people. You need to define what aspect of your business are you going to put under IP. You might be thinking you've developed something new that needs to be put under IP, but when you do your detailed research, you find it actually exists. And you saying that is your own creation of your mind, this is pretty much a hard sell. So getting to to the lawyers and the experts on IP. That's one starting point. Identifying what exactly is your IP. That's a second point. And number three, I believe like if you're operating in Kenya, there's KIPI, and there are all these organizations at the national level that can help you in that process. So having a visit to those guys, going and chatting with them to guide you in the process is one way. But I think this question is from Joy. What is in your locus of control is you defining what your IP is. And I would say throw it there. Find out if it is actually very critical for you to get it registered. You might be so focused on registering it, but maybe your business model doesn't need you to register it as much. Probably your success points in your business model are not necessarily, or rather having the IP registered is not what determines your success. Something else could be what determines your success. So identify what your IP is internally, work with external stakeholders, such as those who are on the call, as well as ourselves, but also their national focal, those national institutions that can help you in the whole process. Yeah.
Thank you. I believe that question was well answered. So on to the last question for this particular session. How can member states, RECs, private sector prepare themselves in order to benefit from the protocol? So maybe just share your insights on how you think people can all prepare to be able to leverage on this particular protocol.
So for me, I come from, I'll be biased. I'll address this to the businesses that might be on the call. And that's because those are the people, those are our clients, those are the guys we consult for, as far as I consult. How best to leverage from this? Like I said, you need to do an assessment internally and understand in your SWOT matrix, is your IP there? If it's there, then you need to prepare to register for it. Now, I hear this all the time, that the cost of getting IP registered is expensive and all of that. I tell clients all the time, put that in your use of funds when you're asking money from investors. Say that you want to register your IP, because what that does from the investor point of view is it helps to de-risk your business. It helps me to see that if you get this IP, then the success of your next 5 years in your business model is more or less secured, is more or less, the return on investment is more or less, I don't use the word guaranteed, but it's a stronger return on investment when you say, hey, I'm actually getting funding to get my IP registered that is so crucial for the success of my business. So as a business model, as a business owner or entrepreneur, whatever, you need to understand how crucial is IP to your business model. You could be operating a business model whereby strategic partnerships is what is stronger than you having a very good IP. Then focus on the strength of getting those strategic partnerships. But if IP is crucial, and here when I talk about IP, I'm mostly shouting at tech-based businesses, because majority of you guys complain all the time that your IP gets stolen by big telcos. Then get it registered. If it's so crucial, then get it registered. If it forms part of your SWOT, get it registered. Don't overlook it. Just because maybe you don't understand it doesn't mean you should ignore it. So for me, I think those are some of the things that on the business side you can take to get ready for this kind of, to take advantage of the IP protocol when it's implemented. Start assessing internally in your house. So what are all the assets that I have? What are all the strengths that I have? Is IP a critical component of it? Now, if I go somewhere else in my risk matrix, the risk of not having IP, can I avoid it? Or can I transfer it somewhere else, right? So if the risk can't be avoided and it can't be transferred, that means you're the one who's going to have to take the hit. Now, if getting IP registered reduces the hit, then get it registered.
For me, again, David has said it all, and I would just like to reiterate what he has just said. But importantly, it all comes down to information. Get information. Information means reaching out to the right people, consulting experts, getting lawyers, IP lawyers to help you. And with information, of course, it also means that it trickles down to the smallest of Africans, the one in the village, the uneducated. It also means that again, the powers that be have information of what IP is and the importance of IP, and perhaps they should come up with the right regulation. So it comes out to information. Information means that with information, and of course, not like a protocol like this one, one, for example, think automatically, because it's an AfCFTA protocol, they can register their IP in Uganda, and automatically to be registered in Egypt. Yet it may not be the case. So information is very important. Information comes with capacity building, and it's information that will lead us to having the right laws as the protocol is recommending. So information is everything. Thank you.
I just want to add one thing that I've just remembered. I know I've talked about this on the application for the business side, and there's one particular segment of technology-based guys that I've thought about. So these businesses that are involved in the fintech space, guys who are either providing payment solutions or payment infrastructure, or providing the whole fintech solutions to the banking sector. I want to give a practical example of why IP is very critical. So you're having, you're a fintech, or you're a fintech, you provide a payment solution, a banking solution, or whatever, to clients who big banks would also be interested in. So you're saying, hey, I can help you make your credit card payments, right? Remember, as you shout that, and maybe there in that system that you've created, there's a bit of an IP there, right? So remember, as you shout that, banks that have the financial resources 10 times yours have the ability to implement the same technology that you're talking about. Now, if you don't have IP on it, that means any other bank in any part of the world can see your same idea and go out and implement it. And those guys have the funding to put that up in half the time it will take you. They have the money to pay the developers. They have the money to pay for the licenses and all the infrastructure that is needed to support that. So I've just remembered that because I know, and we've been seeing an influx of those, especially when this significant boost towards having digital payments came about, even before COVID. A lot of fintechs come up and say, oh, this bank saw my idea and took it up and they ran with it. And we ask them, did you have IP? And they say no, or they say it was in the process. So and the time they're telling you it was in the process of being approved, they've raised money 3 times. So you ask them, all the 3 times you've raised money, hasn't IP ever been part of the use of funds? And when they tell me no, that's when I tell them, you are completely exposed. You created a very new idea, but you spoke about it to people who can take it and implement it faster than you can, right? So that this brings, I'm just trying to bring that example and show how IP is very, very crucial. And it's not just fintech guys, even guys in agtech. We've seen large agriculture input producers implement technology that has been created by small technology companies and run with it. And when they implement that platform in their system, if you don't have IP, they're not going to pay you for it. They're going to build it and move it, right? Why would they pay you for something that wasn't IP protected, right? They want to reduce as much as they can the costs on their side. So it's not just for fintech, it's also for agtech, it's also for any new sector that is being disrupted by technology. If IP is crucial for you to stay relevant and competitive with the big boys, please put that in Series A of your fundraise.
Thank you so much for the insights. I'd like to say thank you for everybody who joined. I don't believe there's any other questions. If there's any questions, feel free to put it in the chat section for now. But otherwise, I would like to appreciate everyone for joining. This was really nice. Thank you, David and Ivan, for the insights that you shared with us. I don't know if there's any last remarks. Other than that, I think we could end the session.
My last remark is just thank you, TradeSmart Consult, for organizing such an event. I mean, it's must be one of a kind so far. I've not seen anyone discussing the draft, even if it's still in draft IP protocol. And thankfully, I've seen some serious IP minds on the call. I would have loved to listen to them or listen from them. I know time is a major barrier. So thank you very much. Thank you to Rose and the team for such a great event. I hope whoever has been on the call has benefited or learned something or taken something into consideration and would like to get back to us either privately or through any other means so that we can further the discussion from here. So thank you very much.
Yeah, for me as well, it's to say thank you to the TradeSmart team. I think this series of 3 webinars have been fantastic. I've put my email address and name and a link to some of the thought leadership we've written around the AfCFTA on the chat. So feel free to reach out to me on email. It's on the chat if you want to proceed with this discussion further or how we may help. Happy to continue the conversation from there. So thank you to TradeSmart. Thank you, Ivan, my fellow panelist, and looking forward to more of these. Thanks.
Thank you, David. I'm not sure I can see your contacts in the chat section. I can see Ivan.
Sorry. Yeah, I think I sent a direct message to someone as opposed to sending it to everyone. So let me just put it on the chat. Yeah.
That's fine.
I think now it's on the chat. Now it's on the chat. Yeah.
Awesome.
Thanks.
Thank you very much, everyone. Feel free to get the contacts of the speakers today via the chat section. I will be sharing the protocol itself via your emails and also the live recording for this particular session that is on Facebook via email as well. And then we can continue any conversations on email. I appreciate you for joining once again, and do have a lovely long holiday. Yeah.
You too, thank you.
Bye.
You too, thank you. Thank you so much.